Okay, we are now live and on the record for Monday morning civil docket for January 31st, 2022. And well, happy Monday, guys. All right, so Ms. Vale, as you were saying, what number are you on the court's docket?
Your Honor, I don't believe I got number 53.
Okay. And that's F 4085-21-9 in the matter of the marriage of Juanita, I'm sorry, how do you pronounce the last name?
Runge?
Runge versus Andrew Runge. Okay, and you're
That's
making the
correct.
announcement on behalf of yourself and Mr. Orozco?
Yes, Your Honor. Mr. Orozco apologizes.
Good, Miss
to the
Emily,
court.
how are
He's
you?
on the road. And so he's unable to make the announcement, Judge.
Okay,
And so basically, we're announcing, we really don't have anything to try, Judge. We just need for the court to set us up for a DCC to get a final trial, and we're done.
okay, so will you be doing a bench trial then?
Yes, Your Honor, there's no children involved here.
Okay, then you can go ahead and file a motion for DCC. We'll get you set up for that, and then that way you all can schedule it.
That'll be fine, Your Honor. Otherwise, we have nothing further to announce with the court. If we may be excused, Your Honor.
Yes, ma'am.
Okay, thank you.
Thank you. Okay, Mr. Bobby Garcia?
Yes, ma'am. We're number 48 on the docket, and we just have to announce that the case is settled.
Great. CL 186758-I, Ramiro Salinas Perez versus Jacqueline Montezuma et al.
Okay.
And
so
how much time do
just
you
to
need
get
for
that
those
recorded,
documents to
that
be
you
filed?
should purchase tires.
30 days.
for-
Give
somebody
me one
said it
moment.
before,
Let
right?
me- Okay, go ahead. I'm sorry, you said 30 days?
Yes, ma'am.
Okay, then I'm just gonna set a tickler for
Judge, we can do February the 4th.
well, they need 30 days to get the documents ready.
If
So,
that.
yeah. Okay, let me just go ahead and set the tickler for March the 4th. All right, well, congratulations.
Thank you very much, Your Honor. May I be excused?
You certainly may.
Yes, ma'am. Thank you.
Thank you. Okay, Mr. Guerra?
Good morning, Your Honor. I have number 38 on your docket.
CO 152834-I, Blanca Barrientos versus Shenshi Chen.
Michael Guetta here for defendant Chen.
Leo, Your Honor, here for the plaintiff, Ms. Barrientos.
Okay, and what is the announcement?
Your Honor, at this time, this was a reset. The court, this is an old case. The court had scheduled for us to conduct mediation with Ms. Melissa Carranza. We have been waiting several months to do mediation. We finally got updated medical records. We supplemented that to opposing counsel last month. Right now, we can go to mediation or we can request a DCC for a trial date. Your Honor, now that new meds have been updated, given the fact of the meds, I don't know if a second mediation would necessarily be helpful in this case, only because we're so far above the policy limits. All my moves to start would basically have to be above limits, and I'd hate for opposing counsel or the court to think that we didn't mediate in good faith.
Okay, Mr. Guerra?
Well, Your Honor, I always think that mediation is helpful, regardless. But I know my adjuster is trying, to get a resolution on this. And we've been trying, once we get this in, to at least try to work something out with Ms. Cedillo.
Okay, so I think that, in light of also what Mr. Guerra says, I do agree with him in the sense that mediation is always helpful, and him knowing your announcement, I still think that maybe you all can try to do something, and if you're willing to work it out. So go ahead and schedule your mediation, and you can talk in between now and then. And if you really feel at that time that it would be a waste of time, then contact us, and then we'll see what we'll take as the next step.
Yes, Your Honor.
But I'll give you all some time. I'll have you guys, I'll have you come back on April the 4th at 9:30.
Yes, Your Honor.
That
All right.
concludes my business before this honorable court. May be excused, Your Honor.
Yes, you certainly may. Ms. Cedillo, you have anything else?
No, Your Honor, may I please be excused?
Yes.
Your Honor.
Okay, Mr. Velasquez,
Good morning, Your Honor. Happy Monday.
happy Monday.
I have two cases before you, Judge. I represent plaintiff in both. Unfortunately, the firm didn't provide the docket sheet, so I don't have the number of their place on the docket, but I do have the party names and the cause number.
Okay, give me party names. I'll see if I can find it.
Yes, Your Honor. The first one is Myra Martinez. She is the defendant.
Number 18, Judge?
I had already passed it. Okay. CL 184216-I Portfolio Recovery versus Myra Martinez.
Yes, Your Honor.
Hold on, let me ask you, Mr. Velasquez, are you going to be doing all the motion for default judgments?
No, Your Honor. In fact, the only one I have are two that before you this morning, and this one has settled, and the second one that I will announce has also settled.
Okay,
Plaintiff has filed motion for continuances with the court, and we are asking the court for 60 days to finalize the settlement, Judge.
okay.
Your
so
Honor,
then-
in response to your last statement, I have the bulk of the portfolio recovery cases.
Okay, then I'm gonna ask you, Mr. McLaughlin, to check back in, because I see that there's a lot of them. And those will take some time, and I suspect that the other announcements are going to be much quicker. If I can have you check back in at 10:30?
Yes, Your Honor.
Okay, thank you, sir, I appreciate it. Okay, so you were saying that the case on Ms. Martinez has settled and you're asking for 60 days.
Yes, Your Honor.
Okay, that's fine. Let's set it for, I'm just gonna set it for a tickler then at that point, because you've already settled it. So let me go ahead and see. I'm gonna set a tickler for April the 8th. Well, I'm sorry, I'm in the wrong month. These things are so confusing. Yeah, it is April the 8th. Okay, I'll set the tickler for April the 8th. Just to make sure that the documents are in.
Thank you,
In your
Judge.
next case,
The last one you have, Your Honor, is Ramiro Munoz. He is the
CO
defendant.
okay, CO 184621-I, that's number 21 on the court's docket. And that has also settled?
Yes, Your Honor.
Okay, and I'll set the same tickler for April the 8th.
Perfect. Thank you, Judge. That's all the business I have before your honorable court. May I be excused?
You certainly may, sir.
All right, Judge. Thanks.
Thank you. Okay, Mr. Ramirez?
Good morning, Your Honor. We're number 44 on the court's docket.
Okay, good morning. CL 210074-I, Jose Cleto Quiroz et al. Versus Norma Hernandez.
Ruben R. Ramirez on behalf of the defendant, Ms. Hernandez.
Selena Faria from the Faria Law Firm for plaintiffs.
Okay, and what is the announcement?
Yes, Your Honor. This is a status conference hearing that was scheduled by this honorable court. Just wanted to update you that we have taken one deposition of the plaintiff. We are still pending a second one as he is currently incarcerated. At least that was my last conversation with plaintiff's counsel. It would not be released until sometime in April of this year. So that's where we are. We'd still be open for mediation if counsel would like to do that. But that's where we're at this point in time.
Okay, Ms. Padilla, anything to add?
No, Your Honor, I believe Mr. Ramirez summarized it pretty well.
Okay, so then will you all be agreeing on a mediator?
Yes, ma'am. Usually Ms. Padilla and I have no issue with mediators.
Okay,
So the only issue was just, if we thought it was prudent enough to go ahead and do it or wait to be able to, take the deposition of the other second plaintiff
Okay, well, I'm gonna give you some time. Let's set a status for May the 2nd.
Okay.
At 9:30. If you need something sooner, let us know, just so that you can keep the case going.
Sounds great. That concludes my business with this honorable court. May I be excused?
Yes.
Wonderful. Thank you. God bless you guys. Have a great one.
All right,
Thank
Mr.
you, Your Honor.
Garcia.
Hello, good morning, Your Honor. Gerardo Garcia here with the Hirina Legal Group. On behalf of the plaintiff, Fabian Ibarra, this is number 41 on your docket this morning, Your Honor.
Okay, number 41.
And I believe Mr. Raul de la Garza is here on behalf of the defendant, HEB.
That is correct,
Okay.
Your Honor. Good morning.
Good morning. CL 21-2380-I, Fabian Ibarra versus HEB.
That's correct, Your Honor. This is a status conference hearing. We have a deposition set for next week on Tuesday, February the 8th. We've already exchanged discovery. This case is proceeding as it should. That's all of my announcement for this morning, unless Mr. De La Garza has anything to add.
That's all correct, Your Honor. The only thing would be if we can please get a DCC on this one, so we can try to get a trial date on the calendar.
Okay, so then are you all going to be, like, how are you all doing as far as the discovery process? Will you be going to mediation, or where are we at with all of those things?
Yes, ma'am. Typically, after we take plaintiff's deposition, I don't know if they're going to want to take anybody from HEBs, and if not, we can go ahead and go to mediation at some point after that.
And will you be agreeing on a mediator?
We probably will, Your Honor. We've worked a lot with this firm, and we haven't had any issues with that yet.
Okay, so for your DCC, just go ahead and file a motion for DCC, and that'll get set, and then we'll give you your we'll work out all your deadlines. In the meantime, I just want to make sure that it's going to continue. So we'll come back on May the 2nd at 9:30, and let's see how far you all have come by then.
Excellent. Thank you very much, Your Honor.
Thank you, Your
Okay.
Honor. That concludes
Anything
our
else?
business before this honorable court. May we be excused?
Yes,
I have one more, Your Honor, but it's a longer one, so I'll go ahead and be on standby.
okay.
Yeah.
All right, Ms. Orellana?
Good morning, Your Honor. I have number 40 on your civil docket.
Okay, CL 180788-I, Luis Cisneros versus Nora Gallardo et al.
And I think I saw Ms. Lisa Vasquez earlier,
Yes.
the defense counsel.
Okay, she may be in another court because she was on with her video and now it's off.
I can wait and for her to return, Your Honor, and you can recall it, please.
Okay, as
Thank
soon as I see her, or just let me know.
Okay, thank you.
Okay, thank you. All right, Mr. Lopez?
Good morning, Your Honor. I have number 34 in the docket, and the reason I wanted to go early is I have a doctor's appointment at 10:30. I'm one of those persons that suffer from COVID long haul, so I have an appointment with a pulmonologist this morning.
Well, I'm sorry to hear that. Okay, CL 200202-I, Rosa Puente versus Ovation Services.
Yeah, I represent Rosa Puente, and I think Mr. Garcia was representing Ovation.
Your Honor, good morning. Mario Garcia on behalf of defendant Ovation Services LLC.
Your Honor, I know opposing counsel had filed a motion to dismiss for lack of jurisdiction, if I'm correct, and I had filed a motion to counter that, but I think talking to Mr. Garcia and the court, you have enough information to rule whatever way you want to, Your Honor.
Your Honor, if I may urge that motion.
Okay, so you're urging your motion to dismiss for lack of jurisdiction.
That's correct, Your Honor.
Okay, and this is the first setting for that.
Yes.
Okay, and do you want to put any arguments on the record?
Yes, Your Honor.
Go ahead.
Your Honor, it's clear on the face of this case that the court does not have jurisdiction. This case arises from a lawsuit in the 206 District Court filed in 2016 for a recovery of a property tax loan debt. So my client, the defendant here, steps into the shoes of the governmental tax entities. A judgment was obtained and signed by the Honorable Judge Rose and the 206 back on May 30th, Rose Reyna, May 30th, 2017, Your Honor. And so what's happening now is the court does not have jurisdiction. It's a county court at law. If anything, the plaintiff is attacking the judgment, which what happened in this case, Ron, it's been almost 5 years, but they filed this in 2020. So their time for appeals is run. Perhaps they could do a bill of review, but that would have to be filed in the 206. So clearly on the face of this case and case law and Texas Supreme Court holdings, the court does not have jurisdiction in this case. There's also another statute I'd like to reference the court with, and that's section 26.043 of the Texas Government Code. That's entitled Civil Matters in which County Court is without jurisdiction. And the court will look into that. It's subpart A, paragraph 8, and it mentions that a county court does not have jurisdiction in a suit for the recovery of land. So what the plaintiff is seeking is to prevent us from going forward with the sale of this property. My client is incurring tremendous economic damage. No payments have been made on this property since 2016. That's almost 6 years now. And we've followed the law properly, obtained a judgment on a judicial foreclosure. There was a sheriff's sale, and my client owns it. So we're asking the court to consider these two major principles here where this court does not have jurisdiction. Thank you.
Okay, Mr. Lopez.
Your Honor, and they may be legally correct, Your Honor, but all through this period, my client has been negotiating with Ovation Service. They requested of her to get $69,000 so they could buy the property, and she has the money, and she's been waiting, but now they refuse to accept the money. My client has been willing and able to pay what they're asking of her. So I think they are using the law for whatever gains they want to make, knowing that my client was making every single effort to get the money, and that she has the money to that they requested of her, because that is her, not besides land, it has a lot of sentimental value to her, and so her whole family group lives there, and she has the money to whatever injuries they acquired. She has the money right now. So I think that she was misled or misguided or whatever, and she complied with everything she asked. So they may be following the letter of law, but they're not following the spirit of the law, Your Honor.
Okay, so do you all have your orders on file?
Yes, Your Honor.
Yes, Your Honor. And just to address that, Your Honor, that's incorrect. We don't have any formal settlement or agreement of any kind. So I would like to note to the court that we made every effort, before taking the judgment. This plaintiff never contacted us. And until now, we hear there's some money that might be coming, but we have nothing in writing to memorialize any agreement. So we ask the court not to consider that part of the argument and follow law on this case. Thank you, Ron.
Okay, I'll set a deadline for myself to get this ruled on by, let me see. Is it the February 11th?
Thank you so much, Your Honor. May I be excused from this honorable court?
Yes.
Have a good day, Your Honor.
Have a good day, Your Honor.
Take care. All right, Ms. Trevino?
Hi, good morning, Judge. Number 43 on your docket.
CO 14218-5-I, Velia Jimenez et al. Versus Bernardino Hernandez.
Yes, Judge. This is Nelda Trevino again on behalf of the plaintiffs. I am here on behalf of Robert Perez. He is the attorney of record. I believe that in this case, he has advised me that he will be filing a default judgment this week. We just cannot get the defendant to file an answer. He has been served. He was served back in 2014. We have filed show cause hearings, served subpoenas on him, hired civil process servers, hired personal investigators, and we just can't get him to file an answer. So Mr. Perez has advised me that he will be filing a default judgment this week.
Okay, just make sure that you file an order setting hearing with that, and I'll give y'all till February the 11th to do that.
Okay, thank you, Judge. May I be excused?
You certainly may.
Thank you.
Okay, Mr. Ramirez?
Good morning, Judge. I think that we're number 1 on the docket.
F 4482-20-9 in the matter of the marriage of Jonathan Ho and Carla Ho.
That is correct, Judge. I represent Jonathan Ho.
And Judge Catarina Alvarado on behalf of Ms. Carla Ho, for the record.
Yeah, Mr. Ho's he's online, Judge. I mean, he's before the court.
Okay, I do see him.
Very well.
Judge, Ms. Ho is not online. It should just be a quick announcement. I will relay. This is set for a final hearing. We're not ready for final, Judge. And it's also set for Mr. Ramirez's motion to compel mediation. We have agreed to a mediation date of March the 2nd with Ms. Edna Cedillo.
Yeah. If I may address the court, Judge.
Yes, sir.
Judge, this divorce case was started in December of 2020. Mr. Ho had filed pro se, and then after that, he hired me so that I came on board. In April of 2021, this court ordered the parties to mediate the case, and we've been trying, at least on our end, very hard to mediate this case. And there have been some cancellations. I think Ms. Ho had some problems at some point, or just didn't go through with the mediation. And then there were some attorney scheduling conflicts. So we set it for close, I think it was prior to September of 2021. Nothing happened, so I filed a motion to compel mediation in September 2021. Thereafter, there was an agreement to mediate. The most recent time, Judge, was on January 12th, 2022. That was the next scheduled mediation. On January 11th, Ms. Ho indicated that she could not go through with the mediation. That was a last-minute announcement because she didn't have the mediation fees. Mr. Ho offered to advance her mediation fees, but wanted credit down the line for the mediation fees. And apparently Ms. Ho is not in agreement, so that mediation was canceled again. That prompted me to file an amended motion to compel mediation, either mediate the case or maybe the court would consider just waiving mediation. This morning, in speaking to Ms. Ho's attorney, we've agreed to try to mediate one last time, Judge, on March the 2nd, but as the court knows, whenever the parties go to mediation, each party is responsible for their share, their portion of the mediation fee. The fact that Mr. Ho has offered to advance the fee for Mrs. Ho because she indicates that she cannot take care of it, although Mr. Ho says that she's working. He wants to finish this case. He's a petitioner. He wants to get divorced, and he still hasn't been able to get to the last step, which would be a bench trial or a settlement. So what I'm asking is for the court to set a deadline for the mediation. We really don't want to be rescheduling. The mediator right now doesn't even want to comfortably give us mediation dates because we've canceled so many times.
Okay, Ms. Alvarado, you're saying that you will make your client available on March the 2nd?
Yes, Judge, and I had discussed this with Mr. Ramirez this morning. And Mr. Ramirez, I know that we've already agreed to a date, so I don't know why he went through that, all the history, but Mr. Ramirez's client has also rescheduled mediation before. It hasn't just been on our side. They hadn't provided any wage information because they said he had zero wage information. So we've rescheduled a few times for COVID related issues, for health issues, for, again, on their part, not having the wage information, which would have made mediation pointless at the time. So we have agreed to March the 2nd. My client has, even though she is working, she has been having some financial difficulties, which is why it was canceled this last time around. But we are scheduled, Judge. My client will be available for March 2nd.
Okay, well, I mean, you all have already agreed to a mediator and agreed to a date. So then March 2nd, the parties are ordered to appear on that date. Let us know what it is that happens. If you're ready for a final hearing after that, we'll set you shortly right after, and I'm going to give me one moment. Okay, y'all will come back on March 7th for a status or final hearing. If you settled, you can prove up at that time. And that'll be at 9:30.
And if we haven't settled, Judge, are you going to give us a bench trial date?
If you all haven't settled, then file, if you're wanting a bench trial, just go ahead and file a motion for DCC, and then we'll get you all scheduled for a DCC, and that way the deadlines can be set.
And Your Honor, one last thing. I know Mr. Ho is willing again to advance Mrs. Ho's mediation fee, but he does want some credit on that portion, since each party should be responsible for their own mediation fees.
Well, hopefully that, I mean, I don't know. I mean, that's something you all need to work out on your own. I'm not going to order any kind of credit to be taken because I don't know the totality of the case. I don't know. I mean, hopefully you all could work that out.
All right. Okay, Judge, I appreciate your time.
Okay, thank you. Anything else?
No, ma'am, may we be excused?
Yes, you certainly.
Judge, I'm also here on number 36 as the amicus attorney. I did see Ms. Rodriguez on. I don't know if Mr. Rubio Salinas' office is on also.
Good morning, Judge. Amber Rodriguez appearing on behalf of the petitioner. Mr. Kennedy is present. My client and I are present. We did participate in mediation.
Let me call the case. That's number 36 on the court's docket, F5234-14-9, in the interest of minor children. Okay, and you said that you attended mediation.
Morning,
Yes,
Judge.
Good morning.
We did attend mediation. We reached an agreement. The agreement has been filed with court. We would ask the court if we could possibly do and I've already sent a draft of the order to Mr. Kennedy, if we could do the order by submission. However, I believe that Mr. Kennedy's client's not here. So if that is not appropriate or work for the court, if we could reset.
Okay, so I do need the parties, at least one party, to prove up the agreement on the record because it does involve minor children. So if Mr. Kennedy doesn't have an objection, since you have a mediated settlement agreement, we can prove it up with your client. Or if he wants his client on, then we can either he can get him on shortly, or we can give you a quick reset so that we can get you get that so that you can prove it up and get this behind you.
Judge, my client wasn't able to get off today from work, which was able to get Thursday off. So I was going to ask if the court could reset it to Thursday. I hadn't spoken to her about.
Thursday's not my civil day. Thursday is my criminal day. Hold on. And I can set you for Friday.
She's available on Friday as well.
Okay. What time?
Anytime.
Okay. Then let's just do Friday at 11 a.m.
That works for me, Judge.
And Your Honor, do I have to be present for that hearing if it's a prove up and there is a mediated settlement agreement? I have received a draft of the order also. I participated in the mediation by phone, I signed off on the mediated settlement agreement as well. And I will sign off on this order once any changes. So I don't know if the court wants me present on Friday or not.
Do you have a conflict at that time?
I may, Your Honor.
Okay.
Yes.
If you're available, then please get on, but if not, just make sure that as long as you approve the order and sign it before the hearing date.
Okay.
All right,
Judge.
so we'll see you back here on February the 4th at 11 a.m. for approval.
Thank you,
Thank
Judge.
you, Judge. May I be
Thank you, Your Honor.
excused?
Yes.
Have a good day.
Anything else?
No, Judge.
No.
No.
Okay, thank you. All right, so I see that Ms. Vasquez Garza is back on, Ms. Orellana, so I'll recall your case. Can you give me the number again?
It's number 40, Your Honor.
All right, CL 180788-I, Luis Cisneros versus Nora Gallardo et al.
And Graciela Orellana for the plaintiffs.
Good morning, Your Honor. Lisa Vasquez Garza on behalf of the defendant. I had to step out. I think I'd heard you calling my case, so I apologize to the court.
Oh, that's fine.
Judge, I think this is just a status conference. I think the last time we were here, the court indicated that perhaps you would be in a better position to start giving some DCC, either DCC dates or trial dates themselves.
Yes. Okay, so now all the issues with the medical records have been resolved?
Yes.
Okay, perfect. Okay, so if you all are ready for trial, just file your motion for DCC and then we'll get you set up for that. And then that way you all pick the trial date that you both are available for. And how long do y'all need to file that, get that filed?
Oh, we can get that filed this week, Your Honor.
All right, then I'm just gonna have a tickler for February the 11th to make sure that it's been done.
Very well, Your Honor.
Will do, Your Honor.
Okay, anything else?
That's all we have at this time. Have a great day.
Okay, y'all have a good
Stay
one.
safe. Bye-bye.
Thank you. Mr. Sabo?
Good morning, Judge. I've got number 46.
CL 211790-I, Sarah Nahera versus Jessica Medina et al.
That's the one. I've got the defendants. Chris Sanchez is on the other side. He called me. He said he's got something, a divorce or something in another court. This is set for status. We've exchanged written discovery. Probably just need to chase down a few documents, take depositions, set it for mediation, and then request a DCC.
Okay, and can you all agree to a mediator?
I'm certain we will be able to.
Okay. Okay, I'm gonna set you off for a status on May 2nd at 9:30. If everything's been done by then, where you've already mediated it and you're ready to file a motion for DCC, if a motion for DCC is on file prior to May the 2nd, then you won't have that status hearing because it'll just be useless.
Okay. Very good. That's all I've got. May I be excused?
You certainly may. Have a good day.
Thanks, you too.
Okay. All right, Ms. Cantu del Bosque.
Good morning, Your Honor. I have number 54 on the docket.
Okay, give me one moment. Mr. Sanchez, Mr. Sabo just made the announcement on both of your behalfs. And so he announced that you all were still exchanging discovery. You would be able to agree to a mediator. I set you for a status for May 2nd at 9:30. I did let him know that if you all had everything done between now and then and were ready to file a motion for DCC, it wouldn't be necessary to do that status hearing and we just go ahead and conduct the DCC.
Thank you, Your Honor. Yes, we conferred this morning and we spoke and we've been exchanging discovery and I believe we're going to agree on a mediator soon. But may I be excused?
Okay, yes.
Thank you.
All right, go ahead, continue.
I had number 54, Judge.
Okay. F 4762-19-9 in the matter of the marriage of Daisy Trevino and Carlos Trevino.
Yes, Your Honor. Cynthia Cantu del Bosque on behalf of the respondent. I'm the attorney ad litem appointed for the respondent.
Good morning, Your Honor. Yuri Sejas here on behalf of Daisy Trevino, the petitioner.
Good morning, Judge Savannah Gonzalez. I'm the ad litem for the minor child.
Your Honor, Ms. Dora Garza is the guardian ad litem for the respondent, and she's not present this morning. However, she's available if the court needs her. Judge,
Okay, what is the announcement?
we're set for a status today, Judge. On this particular case, discovery has been responded to by the petitioner. I had sent out a second set of or requests for production. I'm reviewing those and I've provided them to the guardian ad litem. Your Honor, I just need a little more time to discuss that with the ad litem to see if all of the funds that are not part of the community estate were indeed sent to Mr. Carlos Trevino's separate estate, that being his guardian ad litem for the estate. And then other than that, Judge, I just need to, I guess, confer with Ms. Gonzalez to see if there's any update on the recommendation for in-person visits for Mr. Trevino, Judge.
Okay, Mr. Cejas, anything to add?
No, Your Honor, we actually followed the court in order setting final hearing on the 28th of this month, and we would just ask the court to set for final hearing so that we can get this moving along. I think that once Ms. Del Bosque confers that we hopefully will get this thing resolved.
Okay, so what I'm gonna do instead of an order setting hearing and have everybody say, oh, I'm not available this date, that date, whatever, I'm gonna just change that into a DCC so we can all have a conference call. Well, not me, right? But you with my staff. And so we can get that set for you all. And that way everyone has their calendar in front of them, being that we're dealing with, 4 or 5 attorneys. We make sure that everyone's going to be available and we don't have anyone having a conflict. Ms. Gonzalez, anything to add?
No, Judge, I haven't received any updates after we changed the schedule. I think the biggest thing was those daily phone calls that were kind of disruptive on the weekends. My understanding is that the new schedule seems to be working out well.
Okay, great. All right, I'll give y'all an opportunity. Just keep Ms. Garza in the loop. And Mr. Cejas, you said you filed that on what date?
January 28th, Your Honor.
Okay, I'll have my staff look for that and then we'll get that marked up and sent back to all of y'all, okay?
Okay, thank
The
you.
only other matter is that we had
Let me fix my hair.
scheduled a mediation in this matter, and that was passed because discovery was still ongoing. Will the court's DCC order that a mediation occur, or will the court waive that mediation if the parties are able to reach an agreement?
If the parties reach an agreement, that's not necessary to mediate. However, the mediation deadline will be on your docket control order. And just in case you don't, come to an agreement altogether. And this is a very special case with very special circumstances that obviously, no 2 cases are the same, right? But this one is just a little bit more complicated than most. So I do encourage you to try to come up with an agreement on your own, unless you need some assistance to facilitate that agreement, because each of you are in a special set of circumstances. So all of y'all together, I know, can collectively come up with something that will work in this unique set of circumstances, and only you all know what's going to be in the best interest of your clients and also of the child. So, I encourage you to do that. But of course, if you need to mediate, if you need assistance in selecting a mediator, let the court know and I will. But also choose a mediator that will have the personality to be able to deal with this type of situation that you all are in, okay?
Yes, Your Honor. And we had already agreed on a mediator as Sebelia signs, Judge.
Okay, great. Okay. All
I
right.
think, Your Honor, the hope is that we can get this resolved without needing to use Ms. Sign. So that's
We will definitely try, Judge.
Okay.
Thank you.
All
very
right.
much.
Well, good luck to you all. And
Thank
what we'll do is, since we're going to go ahead and get that set for the final hearing, then I won't set you off for an additional status unless you all call in for something, okay?
Thank you, Your Honor.
All right.
Thank
Okay,
you,
Mr.
Judge.
Cejas, I see. If nothing further, Ms. Cantu del Bosque, you have another case?
Nothing further, Your Honor. May I be excused?
Yes, Ms. Gonzalez?
Nothing further, Judge.
All right, Mr. Cejas, you had number
Number
what?
42, Your Honor. Number 42 with Mr. Flores.
Okay, F 4578-19-9 in the matter of the marriage of Maria Garza and Robert Garza.
Yes. Good morning, Judge.
Good morning, sir.
Good morning, Your Honor. Yuri Sales here on behalf of Maria Graciela Garza, the petitioner.
Mr. Flores, on behalf of Robert Garza, Your Honor.
All right.
Your Honor, we're set for a status here this morning. I think that, I don't know if Mr. Flores would agree, but I think we have several motions that need to get heard that we've reset for one reason or another, whether it's been COVID or just the availability of counsel. I know that the last one we filed was on July 21st of last year. It's just a list of all of the pending motions. The main ones being the depositions of Mr. Garza, Elva Alanis, and then having the court re-interview the child as well.
Okay, Mr. Flores?
Judge, there are several pending motions, but there's one that we've actually already agreed to and we can't get it done. And I'd like to get an order to say that they're going to make the properties available for the appraisal. There's 3 properties in particular. It's the daycare center where the mom or their client is running, the home where the mom lives, and then a property on 495 in Veterans. And we had already agreed to the appraisal, and it's every time we try to get a date, their client doesn't make herself available to get it done. So I'd like to get an order signed today saying that they will make those properties available at least in the next 30, 40 days. So, I mean, I think it's reasonable, but that's going to be the big, I think, sticking point in this case. Until we get the values on there, we're going to have a difficult time settling this case.
And I don't have a problem getting dates for him, Your Honor. I don't know whether or not my client has been the issue as far as getting the property shown, but our last Rule 11 agreement, actually, I pulled up, said that we would get them dates. And it also said that Mr. Flores' office would get us dates for the deposition of Mr. Garza and Elva Alanis. So as long as we have something where we can get the depositions done, Your Honor, I don't have a problem getting him dates for the appraisal so we can get this forward.
Well, it shouldn't be tit for tat, Judge.
No, I don't think it's, I'm not saying
the
it's tit
truth
for tat.
is that the truth is that they had agreed to the mediation, the appraisal dates. And that's probably the more hindrance of the case. There's a child custody evaluation that's basically complete, and I don't think the child's the main issue here anymore. I think the issue is primarily the value of these assets. And if they will agree to provide us some date, well, we have to get the appraiser, and appraisers have been very busy. I would like to get the appraiser to give us multiple dates, send it to them, and then they can accept which dates are good in the next 30 to 40 days.
Okay, so if you all have an agreement on anything that you have an agreement, then of course you all prepare the order, submit it, but that order has to be signed by both of you all. And if that order is signed by both of you all, I'll sign off on it, and that way you all can have an enforceable order to enforce on one another. So on whatever you all have an agreement on, we can take care of that. On anything else, as any outstanding motions that you have, I do see there's several. On any of those outstanding motions, if you want them set, go ahead and file an order resetting hearing on any motions that you want set. We will pick a day and make sure that everyone is available, and we'll get all those motions heard. Okay, right now, those are looking to be either on a Monday afternoon, Wednesday afternoon, or Friday morning, just so that you all know that those are, you can start looking at your calendar for those dates.
Monday, Wednesday, or Friday afternoons?
No, Monday afternoons, Wednesday afternoons, or Friday mornings.
Got it. That'll work.
So just let me know, and then, but you all have to file your orders resetting hearings, or else I'm not going to know that you need those set again. Okay.
Well, and Judge, I'll confer with Mr. Flores in his office about deposition dates and whether or not there'll be a need on the depositions, and then I'll also confer with him about dates for the appraisal as well.
Okay.
So that way we can let the court know what pending motions actually need to get set, and I believe he had a list of pending motions as well.
That's correct.
And so that way we don't have to waste the court's time. We can hopefully confer with the majority of these motions and get something resolved.
Okay.
All right. Thank you, Judge. It's good talking to you. Good seeing you again.
Thank you. Likewise.
That is all the business I have before this honorable court. May I be excused, Your Honor?
You certainly may.
Thank you,
May I
Judge.
be
Have a good
excused,
day.
Your Honor?
Yes. Thank you.
Thank you, Your Honor. Have a good one.
All right, Mr. Quintanilla.
Your Honor, good morning. I'm here on number 33.
Yes, Your Honor. Good morning as well. Reno Gonzalez here for plaintiff judge. Same thing.
I represent the Vasquez, Your Honor.
Judge, I represent plaintiff Mr. Carrion, Your Honor.
CL 202058-I, Martin Carrion versus Juana Vasquez.
Yes, Your Honor, and the issue we had carried over from last year was a motion to compel the medical records that Mr. Gonzalez has already provided to me. And one thing I must say on the record, I appreciate him giving me statuses through text messages. So that kept me going, making sure that whatever the court ordered got resolved, and it did get resolved, Your Honor. So at this point, Judge, we need to take a round of depots and then set it up for mediation, which Mr. Gonzalez and I see no reason why we cannot agree on a mediator. There's an intervener involved, Judge, that is represented by a lawyer named Victor Perry out of Eagle Pass, but it'll be a matter of us all coordinating a mediation in the future, Your Honor.
Okay. Anything to add, Mr. Gonzalez?
No, Your Honor, he's been spot on with everything he said, and I appreciate him as well. And I thank him for taking my text. Sometimes they're at odd hours, and that's all I have to say, Judge, but thank you.
Okay, great. Well, I appreciate you gentlemen working with one another on this. I know that it is difficult, especially during the times that we are in right now. So then what we'll do is we'll come back for a status on May the 2nd at 9:30.
Yes, ma'am.
Yes, Your Honor.
And you guys just keep working up the case.
Thank you, Judge. Have a wonderful day, Your Honor.
All right, you too. Y'all take care.
Be safe out there. Bye-bye.
Thank you. All right, Mr. J.R. Garza? Now you can unmute yourself, Mr. Garza.
Oh, Judge, I apologize. I missed that because my assistant was talking to me. Your Honor, I remember.
Don't blame everything on your assistant.
She was just here, Judge. I'm just kidding. Judge, I'm here number 2 on Your Honor's docket, F-345321. I
Okay.
represent Omar Daniel Villanueva.
All right, and that's in the matter of the marriage of Omar Villanueva and Perla Villanueva. Who represents Ms. Villanueva?
She's pro se, Your Honor. So
Okay.
last time that we were here, we agreed to do an informal mediation. And we simply got stuck on the fact that she didn't want a step down on the child support. So I think at this time, even though we're set for a final, Your Honor, I think if Your Honor would order us to formal mediation, that way she would at least have the mediator to tell her more or less where she's at and stuff. That would
Okay.
appreciate that, Judge.
All right, Ms. Villanueva, can you hear me, ma'am? Okay, you're on mute.
Can you hear me?
Yes, ma'am. Are you going to continue to be pro se?
What does that mean? Like,
Will you continue to be representing yourself, or will you be hiring counsel?
I'm probably gonna be doing it myself. But we haven't like really came out and with an agreement, and we've only had this once. And then I went with the form that he sent for me to review for the agreement. Like I was trying to see it again and they removed it. So how am I supposed to know what they want if I can't continue reviewing it? And 2, we had like a mediation meeting, but he couldn't meet and I couldn't meet that day. So we haven't even really done anything to kind of come into an agreement. Like to me, I just want to do everything for the best interest of the kids. Like I've never like opposed myself. We're going on 4 years separated, and I have never ever denied him to see his kids or anything because the issues are between me and him, nothing to do with the kids. So the thing is that I feel like we need to come into an agreement. And like I said, but if we've only talked once, I don't think with one conversation we're going to get anywhere.
Okay, so they're not required to do an informal mediation. So really, they're not even required to have one meeting such as the one that Mr. Garza has extended to you. But you are required to go to mediation, to a formal mediation prior to having any contested hearing in my court. So an order of referral and mediation will be sent out to you today. Can I get an email address for you, ma'am?
Yes, it's PEARLYV as in Victor, T @gmail.com.
Okay. You'll be receiving that order of referral of mediation sometime this afternoon. And then that mediator will contact you as well. So make sure that you're on the lookout for that, okay?
Okay, sounds good.
All right.
Your Honor, I already
And then-
filed that order.
You filed that order already?
Yes, Your Honor, I just
Okay,
did.
then I'll have that forwarded to my queue.
Thank you, Judge.
Also my address has changed, so if any address, like any documentation, like, I would like you to send to a different address, so.
Okay, what is the new address that you would like your the future settings to go to?
It's 1018 Nieves Rodriguez Street, Wesco, Texas, 78599.
I'm sorry, could you give me the street again, please?
It's Nieves Rodriguez Street, Wesco, Texas, 78599.
Okay. All right, ma'am, then be on the lookout for that, okay?
Okay,
So for right now, I'm gonna give you a status for April the 4th. And if you get it worked out before then, let us know and we'll get you set before then. If not, if you have it worked out by that date, then we can also prove it up on that date. It's April 4th at 9:30.
Thank you, Judge. May we be excused, Your Honor?
You certainly may.
Thank you.
Yes, I have it. Okay, Mr. Leibowitz,
Good morning, Your Honor. We're number 50 on your docket.
good morning, sir. CO 193914-I, Catherine, is that supposed to be Garcia
Yes, ma'am.
versus Progressive Skilled Home Health Services et al.?
Your Honor, Jacob Leibowitz for the plaintiff, and I believe we have Mr. Javier Peña and Mr. Steve Haynes as well.
Morning,
That's correct, Your Honor. Good morning.
Oh, good morning. Mr. Peña, I just want to give you my condolences, sir. I'm sorry. I understand that you had a loss in your family not too long ago.
Yes, Your Honor. Thank you.
Okay, and what is the announcement, counselors?
Your Honor, this is a status hearing. We originally had, the parties are all working together to get the last deposition done of the minor plaintiff. We're just trying to work around different scheduling issues as well as the minor's schooling. At this point, really, the parties are working to get that final deposition scheduled, and then we'd like a DCC.
Okay. Anything to add, Mr. Haynes or Mr. Peña?
No, Your Honor, this is a old case. The accident happened back in 2012 and was previously in another court, and then it was non-suited right before the trial date and refiled in your court. So we'd love to get this case resolved this year.
Okay, Mr. Peña?
Yeah, same announcement, Your Honor. I think we're working well to get that last deposition done, and then we can move to trial after that.
Okay, so, and what about a mediation? Are you all going to agree to a mediator?
I believe it mediated, and it might have been before I was involved in the case, but I believe it already has been mediated.
I think it was mediated under the old court, wasn't it?
Yes, I think so. It was mediated some time ago.
I don't think it would be an issue to attend another mediation, Judge, and we can have that as part of the docket control order.
Okay, go ahead and file a motion for DCC and we'll get that set for you, and then we'll go ahead and get those so you all can work off those deadlines.
Thank you, Your Honor. I don't have anything else.
Yes, Your Honor.
Thank you, Judge. May we be excused?
You certainly may.
Thank you, Judge.
Thank you, Your Honor.
Thank you. Okay, Mr. Palacios?
Good morning. Good morning, Judge.
Good morning, sir.
I have number, I believe it's 35, Judge, on the court's docket this morning. Yes, 35, Judge. And I'm here for the defendant, Angelica Mendoza.
210174-I, Guadalupe Monsiváis versus Angelica Mendoza.
Good morning, Judge. Frank Garza for the plaintiff, Judge.
Okay.
And it's our motion to waive mediation on this case. We've discussed this in the past, but I filed a formal motion. Judge, on this case, the way we view this case, it's a policy limits case. My client's got in excess of $15,000 in medical. The defendant has a nominal policy, multiple herniations and multiple levels in the medical that indicates that, we're going to go seek a surgical recommendation. So policy limits aren't even sufficient. A mediation, Judge, is not going to be fruitful. It's only going to be adding an expense to the plaintiff. My experience with the Chavez Law Group, two other cases, Judge, out of Court 8. In one case, they offered me the same offer they did in pre-lit, $500. In the second case, they went up $300 from the pre-lit offer, Judge, and well below the policy limits on that case as well. So, Judge, just for efficiency and not wasting resources and money of my client, we like to just get a trial setting. We do have a DCC the 11th, Judge. Now, Mr. Palacios and I have not mediated yet any cases with that, but the adjusters and the carriers really, as we know, or the court may or may not know, is who dictates what they do on these accident cases. And so we just need to get them to trial and get a verdict, Judge, one way or the other. Discovery's been done on this. My client's been deposed already. Our medical is proven up already, Judge. So we'd like to just get a trial setting on December 11th on the day of the DCC, but the mediation, Judge, we like in this instance to waive it. I've always believed in them, but in this instance, in this law firm, and this carrier, I just don't see it being fruitful, Judge.
Okay, Mr. Palacios, you want to respond?
Yes, ma'am, if I may. Obviously, Judge, I would object to waiving any sort of mediation. I believe that they're all helpful. I'm not sure what experiences he's had or, in detail with these two other cases, Judge. But as you averred to earlier, all cases are different, Judge. We evaluate this case in a different way with a different set of eyes than Mr. Garza evaluates this case. This is an issue with damages, Judge. And there were no injuries that were indicated at the scene, and plaintiff did wait over 3 weeks to even see anybody to treat, Judge. And so, the damages are at issue. So for Mr. Garza to come and say, hey, all the damages are proved up and everything's proved up and everything's in excess. He mentions a surgical recommendation, Judge, that has not been even sought out in over 3 years since the accident had occurred, Judge. So, I'm not sure what delay or what he's waiting for as far as, his plaintiff looking for surgical if that's what it was. But I don't think there was any reference to any surgical recommendation made in the medicals that he had provided to date, Judge. Now, I definitely would want to have a third party, in this case, a neutral mediator, to evaluate the parties' claims and defenses and assess the court and the parties in helping to try and amicably resolve this case, Judge. But with respect to his claims that this law group and or adjusters have shortchanged him or his clients, Judge, I don't know if he took those to trial and those resulted in verdicts that were drastically different from what were offered before, if that's even happened. But to me, these are just baseless arguments, Judge. And as plaintiff's counsel has averred to in 2 prior hearings before this, Judge, he's never had these kind of dealings with myself. I represent the client. I report to an insurance company, but I myself represent the client as seeking the best interests of my client. And so, I definitely object to any sort of mediation. We do have a trial date coming up. We do have a DCC date, Judge, coming up, in which a trial date will be set. But just for him to say that everything's proven up and he's got this gift wrap case, Judge, that's what discovery is for. That's what litigation is for. I don't agree with it. But for those reasons, I definitely want to have the opportunity or give my client the opportunity to attend mediation. And I understand if there's fruitless mediations, a lot of times parties or plaintiffs want to set mediation early on without much discovery being done in order to save a buck. I've never received any mediation requests in the time since Mr. Garza had filed his suit over a year ago. So any urgency to try and resolve it, I've never been relayed any sort of correspondence or phone call to try and see if we can resolve it or with any numbers. So quite frankly, it's the damages case with a little bit of liability there that I see it on the surface. And so, we get our trial date, Judge. I still get time to work up discovery. And if I have to go out and spend money on behalf of my client for experts or whatnot, I definitely want to get my case ready before attending a fruitful or meaningful mediation. But I don't believe that anything that myself or any dealings between myself and Mr. Garza have ever resulted in any need to go and seek the court out in trying to waive mediations or anything. I've never had any reason. I've never worked in any negative way with Mr. Garza nor Mr. Peña. And so I'm hoping that throughout the duration of this case that we can continue to work together to try and resolve it. And if need be, you know, if it has to go to trial, Judge, it has to go to trial and the amounts don't match up. But, you know, if he's not inclined to mediate right now, as I've never received correspondence, I wouldn't be inclined at this moment, Judge. I mean, there's still experts that I would want to hire. There's still some discovery that I have not yet to be received regarding any lost wages that they agreed to provide or that they were in deposition that they would be providing my office. And so my evaluation of damages really it's incomplete. And so I wouldn't agree that mediation right now would be fruitful. I think down the line it would be in light of the expense that would be incurred on both sides, our side included, Judge, in going out and paying for trial.
Okay, so this is what we're gonna do. The DCC is gonna move forward on February the 11th, and you all will have your deadlines. I'm gonna carry this motion over until technically you'll have the 30-day deadline prior to your trial date. So if you're gonna want to re-urge the motion once you've already worked it up and gotten close to that trial date, just go ahead and file your resetting hearing. We won't have to go unless you have something to add. I'll remember these arguments anyway. So, but we'll go ahead and take it up at that time. In the meantime, just continue to work towards your deadlines when you get your DCO after February the 11th. And then if it's necessary, we'll come back and we'll revisit this issue again. But I think it's premature at this time to see whether or not mediation would or would not be fruitful. And so, but it doesn't mean that we won't look at it, okay?
Judge,
I'm okay with that. Thank you, Honor.
Below your Stowers deadline, Judge, so they offered $1,000, so price is gonna go up after today. And as I work it up, so policy limits won't even be enough, Judge, so.
No, and I understand that. And I'm sure that Mr. Palacios, you all discuss it and you've made him aware of it. And he understands that you're right now, you're looking at an excess of the policy limits. And if he knows that you're in excess of the policy limits, then I don't know what wiggle room he has beyond that, if any, I understand all of that. So it's just, so we'll just, but it's really, the ball will be in his court to see how he can convince anyone on his team to see how you can give in excess of,
And that's good. I'm sorry, Judge. What? And that's correct, Judge. With throwing that word out here, saying Stowers and blowing it, Judge, I still don't even have lost wage information. So I'm not sure what kind of evaluation I can actually make without a complete set of records pursuant to the damage that he's alleging, Judge. So I don't, that's just my reply to it, Judge. I really don't appreciate those kinds of words being thrown out in a pretrial hearing, Judge.
You both are very excellent advocates. And in the spirit of advocating in your case, you all have to also understand that, as a judge, I was in your shoes before. It doesn't mean I'm not the juror. So I know how to take these arguments. I understand, and attorneys get very spirited and that's okay. And then just because you all say one thing doesn't mean that I'm going to take it as you all don't mediate well or play well with others. Okay. Just don't worry about it. I understand. And I totally see both of your sides. Let's just continue to work this up, have your DCC. You'll get your DCO, your deadlines on your DCO, and then we'll take it up at the time. Mr. Garza has been very frank, no pun intended, has been very frank in giving you, the situation. I don't think he's hiding the ball or anything. And so as long as you understand Mr. Palacios as well, then you'll know how to deal with it on your end, right? So, but I trust both of y'all very much. And so we'll just take it up at that point, okay?
Thank you, Judge.
Honor.
Okay, y'all have a great day.
You stay safe, Judge.
Okay, thank you. Okay, Ms. Sepulveda Martinez.
Good morning, Your Honor. I have number 3 on the court docket.
CL 181841-I. Number 3, you said?
Number 3, Your Honor.
Midland Funding.
Funding. Yes.
Okay. Midland Funding versus Crystal Cobos?
Yes, Your Honor. We're just asking for a little more time. The defendant was just served.
Oh, okay. Do you know what date the person was served?
I do not, Judge, but I know.
Okay, let me see if the return is on file. Give me one moment. I don't see, you might want to check. I don't see that the citation has been returned unless, Ms. Rivera, you see it under something else.
Let me double check, Your Honor.
Okay. I know that there was an order for alternative service that was signed.
Judge, it was just a certificate of the last known address, but I don't see.
Okay, you might want to check with the firm because the citation has not been
It's not
returned.
returned. Yes, Your Honor.
Okay, but I'm going to go ahead and give you a status hearing on May the 2nd. And if you settle something before then, just let us know. And it's May the 2nd at 9:30.
Thank you, Your Honor. That's all I have. May I be excused?
You certainly may. Thank you.
Thank you.
Patience. All right, Mr. Guerrero. Mr. Guerrero, you're on mute. I hope you didn't waste a good announcement on that.
Oh, sorry about that, Judge. I have number 47 on the court's docket. Victoria Molina is my client. She's present in my office.
F0108-21-9 in the matter of the marriage of Victoria Molina versus Silvano Molina.
That's correct, Your Honor. Silvano Molina should be there. He should be online.
Okay,
Yes,
and
yes.
is this case ready to be proved up?
Your Honor, we did mediate. We were successful for the most part. There is a dispute on the amount of child support that should be paid in this case. Oddly enough, we agreed on everything, including when child support should start. There's a big difference. So we, in response to our inability to settle that particular issue, sent Mr. Molina discovery so we can have a snapshot of his, income, and then we can calculate it. And should he still be in dispute, we can always just take that one issue on a final hearing before the court. He was sent the discovery, I want to say on the date of mediation, which was sometime last week. So he's going to have 30 days to respond. Maybe if the court could give us a date certain for a final prove up, and we'll just take that one issue before the court, and it should be pretty much done, Your Honor.
Okay, April 4th at 11 a.m.
Thank you, Judge. May we be excused at this time?
Yes, you certainly may. Okay, Mr. McLaughlin, are you still needing to go to court 5?
Yes, Your Honor.
Okay, so then you're going to be there for a while?
I'm going to be there for a while.
Oh, okay. All right, because we have one contested matter still before we were going to take you up. Let me see.
Judge, if it's easier, we can reset him. I just need new order resettings. There are a good amount of motions for default for this morning, Your Honor.
I will work with the coordinator to give her the numbers from today's docket.
Okay. All right. Thank you, Mr. McLaughlin. And we'll make sure
Thank you.
To carve out some time for you on that one.
Good morning, Your Honor. This is Jorge Peña.
Okay. Yes, sir.
Yeah, I do have a case with Mr. McLaughlin. Just wanted to see if that's gonna remain for today, or is that also gonna be?
No, it's going to be reset because he had a good chunk of cases and he has an appearance that he has to make in another court. So if you can just give me a good email address for you, and we'll make sure that the new date is given to you. And that's
Okay.
number 49 on the court docket. Go ahead, Mr. Peña. What's your,
Yes, it's Jorge with a J, Jorge dot Peña, Pena, 1979 at att.net.
okay, thank you, sir, and thank you for your patience.
Thank you. Have a good day.
Thank you. Okay, Mr. De La Garza, who do you have your hearing with?
Good morning again, Your Honor. I have it with Michael Moore, and he's present there.
Okay, and you said that's going to be some oral arguments?
There are, Your Honor, yes. I anticipate from my side about 20 or 30 minutes. I don't know.
Okay, let me go, and Mr. Moore, how much for your side?
I'd be shocked if we go 30 minutes, Your Honor. It's not that, it's not that complicated.
Okay, let me go ahead and take Mr. Hudgens and any other quick announcements before we get into your case.
Thank you,
Go
Judge.
ahead, Mr. Hudgens.
Your Honor, I'm number 32 on the docket. It is a contested hearing, but it's a summary judgment, but it may take 10 minutes or so. It's fairly straightforward.
Okay, I see that Mr. Sahadi is also on.
Yes, I saw him on there.
Good morning, Your Honor.
I didn't know, I'm not trying to hop in line. I saw you said there's only one contested hearing, and I wanted to make sure that, I didn't know if it was ours or the other one, so there are.
Okay, no,
It is contested.
all right. And then let me see, Mr. Cavazos, how long is, do you have a quick announcement on yours, sir?
Good morning, Judge. I'm here, number 39. We haven't had the opportunity to talk to the OAG. I believe both parties are here, Judge. I don't know
Okay,
if.
the Ms. Alcantar just logged in. I'm sorry, Mr. Alcantar just logged in from the OAGs. Do you want me to put you in a breakout room, or did you want
Judge,
to
if you
confer on your own?
Judge, if you may put us in a breakout room.
Okay, let me go ahead and do that. Mr. Alcantar, Mr. Cavazos is requesting to be placed in a breakout room to confer with you. Are you fine with that?
Yes, Your Honor, it's okay.
Okay, let me go ahead and create that.
Thank you, Judge.
Thank you, Judge.
You should see that invitation there. Okay, any other quick announcements before we get started with some longer announcements? Okay, let me go ahead and take Mr. Hudgens up, since that one should be shorter than yours, Mr. Moore and Mr. De La Garza. I'm sorry, what number was that, Mr. Hudgens?
32, I believe.
Okay.
Let me make sure. Yes. Do you need the cause number?
No, I have it. CL 196266-I Maria Matilde Cardenas versus Stuart Bell, BEALL et al. Go ahead. Announcements.
Judge, I represent Stuart Beal. He's one of two defendants that have been served in this lawsuit. The other defendant, his wife, actually hasn't been served, so she hasn't had to make an appearance. And this is a pretty straightforward motion for summary judgment against the plaintiffs. This incident occurred back on November 25th of 2017, and plaintiff, Ms. Cardenas, filed her lawsuit on November 25th of 2019, the day of the statute of limitations, the last possible day. But Mr. Beal, Stuart Beal, was not served with the lawsuit until almost 9 months later in August of 2020. And so, as the court is well aware, simply filing the lawsuit on the day the statute runs doesn't satisfy the limitations bar. You still have to exercise due diligence. And we sent discovery on what was done in the intervening time between November 25th of 2019 and the time Mr. Beal was served, because the court's own record indicates citation was issued the day after the suit was filed. And quite honestly, we didn't receive anything that we thought showed due diligence in trying to serve Mr. Beal during that time period. So we filed a motion based upon that issue. And in response, the plaintiff has basically said, well, we didn't really know where he was, and then COVID hit, and so that was the delay. And I would argue that they have not met their burden in showing what they did to serve Mr. Beal If you just exclude COVID, the incident occurred, the deadline, the suit was filed November 25th of 2020. I think we'd all agree COVID, at least any shutdowns, didn't start until early March of 2020. So we have from November 25th of 2019, I should say, up until early March of 2020, nothing was done. And the case law is pretty clear. If there's a delay in trying to serve a defendant and you're beyond the statute of limitations, you got to have an explanation for that delay. Otherwise, as a matter of law, you didn't exercise due diligence and you don't get to revert back to the date of filing to preserve the statute of limitations. That's pretty much it, Your Honor.
Okay, Mr. Sahadi?
Hi, Judge. I think the times speak for themselves. 2020 was a challenging year for any individual. One thing I would point out, Judge, is that the plaintiff and the defendants used to live next to each other. However, and in fact, I think it was during the course of their moving when they were holding a garage, so that my plaintiff, my client was injured. Now, they moved out of the valley, Judge. Mr. Hudgens stated that we didn't have a clear idea of where they were headed. We had no idea where they were headed. And it was only after we located an address for them in Houston, we served them, Judge. Now, because of the COVID, I know I can only speak for myself, but during March, my office was closed down, Judge. I didn't have any business coming in. I didn't have any business going out, very little business going out. And I think that that because of not having the address first, and then because of the COVID, I think that is more than sufficient explanation why we didn't immediately have the defendants served.
Your Honor,
as soon as I'm sorry, I don't mean to cut you off, but as soon as I received the address from my client, actually my client was the one that was able to locate an address for them. We went out and contracted with someone to have them served, Judge.
Okay, Mr. Hudgens, you were going to reply?
Yes, I mean, the case law I've cited, which is Supreme Court case law, Texas Supreme Court, I'll quote, timely filed suit does not suspend running of the limitations unless a plaintiff exercised due diligence of service in the lawsuit. Only then will service relate back to the time of filing suit. And so the question is, how do the courts determine due diligence? Well, the court's asked to determine whether a plaintiff acted as an ordinary and prudent person would act under the same or similar circumstances when trying to be diligent in serving a defendant. That's another Supreme Court case that I cited, Ashley versus Hawkins. And diligence is measured from the date the suit is filed, which in this case was November 25th of 2019, until the time they actually serve the defendant. Let's ignore COVID for right now. Between late November of 2019 and March 1st, which is over 3 months, there is nothing to indicate that plaintiffs made any attempt to either locate Mr. Beal or attempt to serve him. And I understand that they said our clients moved. I did attach as an exhibit, which the plaintiffs have objected to, and if I need to get it in admissible form, his client regularly texted my clients. And if you look at the text thread, if the court so desires, she knew that they had moved up into the Houston area, and they moved to the house they still live in today. You can go and look at the appraisal district records, all of this online. You can locate where they are. Or she could have just asked them, where did y'all move, and find out the address, but nothing was done. I know this is an unfortunate result for plaintiff, but at the end of the day, the plaintiff has the obligation to serve the defendant timely and exercise due diligence. And, the one case, Prolix, I don't even know how to pronounce it, the Prolix case, the Texas Supreme Court, that case, they attempted like 30 times or 20 plus times a service trying to get this guy served. And that obviously was considered due diligence. Plaintiff has done nothing up until August of 2020 to get Mr. Beal served. And I think a court can determine as a matter of law, diligence wasn't exercised, and therefore this claim is barred by limitations.
Well, I would believe that the emergency orders from the Texas Supreme Court may come into effect. I know that they were implemented during the pandemic, Judge. I just don't recall exactly when, and that basically told the statute of limitations on these. But again, Judge, I mean, yes, maybe she knew that they were heading to Houston, but she didn't have an address, and the relationship between the parties was such that there really wasn't much of a relationship. I can't serve somebody in Houston just because. I mean, I've got to have an address, and they need to have somewhere that they can be either by certified mail or any method put forth by the Texas Rules of Civil Procedure. Initially, that was the problem, and that continued to be the problem until I received an address. At that point in time, I contracted and had them served.
And just one last thing, Your Honor. Like I said, that's why I wrote my motion in a sense that, okay, we've got post-COVID and pre-COVID. Nothing was done pre-COVID. The case law, there's cases out there where nothing's done for 60 days, which is less than that time period between time suit was filed and COVID hit, which I believe the Supreme Court order was like March 15th, thereabouts. The courts have just held as a matter of law that's not exercising due diligence. I understand the potential unfortunate nature of this ruling, but at the same time, obviously, court's got to look at it from my client's perspective. He's getting served almost 3 years after an incident occurred, and so I think he's entitled to assert a limitations defense for the reasons we've argued.
I think we were reasonable, Judge. I looked online. I searched for the parties. I couldn't find anything. In fact, like I said it before, it was my client who was able to find that address. And not knowing if that was the correct address, we had him served there. And it could have turned out that it was a faulty address, but thankfully it was not. It was the correct address.
And Judge, I got to respond. There's no evidence that what he did as far as searching online. That's Mr. Sadahi is saying that for the first time today. He just his response.
Well, I didn't just sit in my office and hope that the address would turn up, Judge. I mean, I searched.
Well, that's not part of his response. I don't know what exactly he did, because I can tell you what I did, and I was able to find their address just independently on my own fairly quickly. But I'll leave it at that. And if there's anything else the court has a question about, I'm more than willing to answer.
Okay. So I'm going to take this under advisement, make sure that your orders are on file. I do see that the order granting is on file. I don't see an order from Mr. Sahadi. And I will issue a ruling and let you know within the next, let me see, by February the 18th.
Yes, ma'am. Now I have that. I'll file that order denying on my part, Judge. I'll file it right away.
Okay.
Thank you, Your Honor.
All right. Thank you.
Thank you, Judge.
Gentlemen. Okay. Before I get started, sir, on the Motorola Moto G7 Supra, what is your name, sir?
Leonel de Leon.
Okay. Mr. De Leon, do you have an email address, sir?
Not in hand right now.
A mailing address, maybe?
Yes, 13, 45-2 mile, 1.5 west, Mercedes, Texas, 78570.
Okay, sir. We're going to send you a new date. I'm sorry, what was the zip? 785 what?
78570.
Okay. The attorney for those cases had to be in another court. So we're going to go ahead and provide him your address and we'll give you the new date. And you'll get it in the mail. Okay?
Oh, thank you.
Okay, thank you.
Just
And you are excused, sir. Miss Span?
Yes, ma'am.
Okay, did you also have a case with Mr. McLaughlin? Or do you have a case number? You're on mute, ma'am.
Sorry. Yes, Your Honor. It's CL 210469I.
Judge, it's the bench trial.
Okay. So I believe Mr. McLaughlin was also taking care of that one.
Judge, we have here Daniel Cabrera for CL 21.
Oh, okay.
Good morning, Your Honor. Daniel Cabrera on behalf of Discover.
Okay, and the defendant is here. Have you had an opportunity to speak to her?
No, I know we had a summary judgment hearing that a colleague of mine wasn't able to appear. I was going to try to orally request a continuance, and maybe that would give us more time also to try to reach a settlement. I found out Friday afternoon that our witness was not going to be available.
Okay.
So,
Miss
and
Span,
so
do
I
you
was
have
going to
an
request a continuance.
Okay, Miss Span, can you please give me an email address for you?
Yes, rspan07@gmail.
Okay. Mr. Cabrera, do you have a phone number that Miss Span can contact so that you can start talking about possibly a settlement?
Yes, Your Honor. I have two. I have my own personal number, and I also have the collections line that I can give her both.
Okay, go ahead.
Okay, my personal line is 512-218-0488, extension 3040. And the collection line is 1-800-370-2251.
Okay, so your oral motion for continuance is granted.
Thank you, Your Honor.
And go ahead and I'm going to set you for a status hearing on April 4th at 9:30 a.m.
Thank you, Your Honor. Appreciate it, and I apologize not having the witness this morning.
No, that's fine. Okay, thank you.
That's all I have. Maybe excuse, Your Honor.
Yes, you both may be excused.
Your Honor, they a letter with AmeriCorps, the company that's supposed to be settling this debt.
You'll need to discuss that with them. That won't be part of anything here on the
Okay.
record for today.
So,
Okay?
Oh, and I would like to say
Discuss it
one
with
thing,
them.
Mrs. Spam. Can I say one thing to Mrs. Spam? I'm not allowed to contact you personally because you have a no contact. So please call us, and we can get going that way.
Okay, thank you. Yes, thank you, Your Honor.
Yes, you may be excused. Thank you.
Judge, could
Thank
you
you.
call? I'm sorry, Your Honor. May you call number 9, Judge?
Yes. CL 1845661-I, Yvonne Dominguez.
Judge, she sent the email through the Zoom chat, which is Yvonne DGZ89@gmail.com, and she asked if we would be sending that notice today. That notice, Ms. Dominguez, will be sent out as soon as the plaintiff files it. So as soon as they file it, we will send it out. I'll include your email address, and they should be sending it out to you. I just don't know. It'll have to be 30 days prior to your hearing date, okay?
Okay, thank you so much. May I be excused?
Yes, you may. Thank you.
Thank you.
Angel Martinez, CL 170795-I. Mr. Martinez, can you please provide us with your email address?
Yes, ma'am. My email address is martinezangel956@gmail.com.
Okay. The attorney for the plaintiff had to be in another court for a long hearing. So you will be receiving a new notice of a new date, okay?
Alrighty. Yes, Your Honor.
Okay, thank you.
Thank you. Have a good day. Bye-bye.
Okay. Mr. Cavazos?
Good morning, Judge. Jaime Casas here. We're back on number 39, Judge.
Okay, F 4922-19-9, and what is the announcement, Counselor?
Judge, I met with the OAG and I guess provided the wage information as far as child support and medical support. I believe that has insurance. We've met with mom in the past, Judge. There is a protective order that was issued by this court back in July of 2021 on an incident that happened back in April of 2020. In the protective order, Judge, both parties decided and agreed to waive the interfering with the exclusive possession of the children, Judge. There were actually 2 children, Judge. This was the dating relationship. And initially we filed back in 2019. They got back together for a while. Dad had possession of the child. I believe mom had been in an accident and dad had the children with him. And then they reunited. And then there was this incident where they separated. And the child, the older child, had dad's last name, and the younger child did not have his last name. And this court has signed an order, an agreed order, Judge, that the oldest child is not dad's and adjudicated as non-parents. So now we're here today on the young child, Bea. And what we're asking the court, Judge, is first of all is to find that Mr. Abraham Diaz, and I believe his camera's off, but I believe he's present, Judge, to find him that he is the father, the biological father of the child. And then, Judge, the older child had a hyphenated name, Diaz Villarreal. So we're just asking that the court approve the name change back to Diaz Villarreal, or to Diaz Villarreal for Bea, in line with what they had named the older child, Judge. I believe the child would be 3 in May, Judge, being that there is a no contact order, and being that there was some issues between mom and dad. Dad did take a BIPP course and completed it, Judge, a few months ago, provided me a certificate that I can provide the court, Judge. We're just asking, Judge, to consider, dad had initially had the child for the first year of the child's life. And then the second year has been kind of tough because mom, we understand she has a, we don't know her address, we don't know her whereabouts. We're just asking for the court consider some access for dad during temporary orders so that dad can reestablish a relationship with his child and eventually be able to visit the child either through standard or extended standard.
Okay, so today it was my understanding that we're here for a status because I just wanted to know what was happening with this case. So Ms. Villarreal, are you going to continue to represent yourself or will you be obtaining counsel?
No, I'm still representing myself as today.
Okay. With respect to what Mr. Cavazos just requested, do you have any issues with the court finding that Mr. Is it Diaz?
Mm-hmm. Mr. Diaz.
That Mr. Diaz is the father of the child, and with respect to the name change, do you have any issues with that?
I understand. Yes, we understand that the child is his, but I am not in agreement with name changing for Bella. I am not in agreement with him reconnecting with my child just for the safety, and I have provided that with the OAJ and as well with everything else that I've provided. I have been very patient with this case through everything we have been through, not just me being in danger, but my children as well being present. So just due to the safety for my children or my child for that we share, I do not approve. I won't accept. I'm sorry.
Okay. So and at the end of the day, if it's going to be up to it's either going to be up to me or up to a jury. And so at this point, since you're representing yourself and I don't see a jury demand, then it's going to be up to me. And yes. So now what you're going to be faced with, Mr. Cavazos, is either you file a DCC for a bench trial so you can get some deadlines down and make sure that all the process is filed, and it sounds like you'll have to work up the case. And, I don't know if you're going to need it ad litem, an amicus, or I don't know what route you want to take. Especially if she's going to be in disagreement with any visitations with respect to dad having any visits with the child. I mean, I can't take it up today, but I can certainly either you have the option of we set it for a bench trial, today, or, I mean, we give you the date today, or you file a DCC so that you all can all be on the same page, and that way Mr. Alcantara also has an opportunity to make sure that the OAG is available. Ms. Villarreal, I know you mentioned that you gave the OAG some information. They are not your attorneys, and they are not there to advocate for your child or children either. They're simply there as interveners with respect to whatever interest the state has. No one else. They don't, it's not up to them, and they don't have an opinion one way or another as to what happens with respect to visitation. They're there to provide information with child support, medical support, make sure that the state protects their interests in the case. Okay, so don't mistake Mr. Alcantara's office for being there to represent you or to represent the children.
No, I've never.
Okay, hold on. Just so you understand, whenever, if the evidence states a DNA or what have you, that Mr. Diaz is the father of the child, whether you object or don't object, the DNA results are the DNA results, okay? Now, as respect to the change of name for the child, then, you know, you're obviously entitled to your opinion, and I'll make a ruling on that as to what the child's last name will be, okay? Now, I don't know, Mr. Cavazos, what you want to do. I know it's difficult to proceed when you have a pro se party on the other side, but do you want to file for a DCC so that you can set date certains on deadlines, or how do you want to proceed, sir?
Yes, Judge, the only thing I brought it up at the last hearing, we still don't have any contact information for her, and I understand, and I don't know if the court does either. And
okay, what I am going to tell you, I
Judge.
know there's a protective order in place. Ms. Villarreal, I'm going to ask you to contact Mr. Cavazos
And
directly.
we have in the last court meeting, I gave him my address multiple times. Everybody has the same address. I've been receiving all my mail and my email. Nothing has not changed. And for the past 2 years, I have been having my child. Mr. Diaz only had her for 2 to 3 months when I was in the hospital. I just wanted to make sure that was corrected, because he said that he had her for the first year. He never had possession of her, only for 2 to 3 months, and that was due to my accident. The address, again, here in Oasis, we've been in Oasis County since the incident in 2020. We have not moved out of Oasis County. The only location we have moved away was because Mr. Diaz found out where my new location was. Now, the one that I have provided for everything that I've been under, it is the same address. I have not changed anything.
Okay. So you can just go ahead and just make sure that he has it. Now, Mr. Cavazos, go ahead and file your motion for temporary orders so that we
Yes,
can
Judge.
get that set for you, and we'll give you some time. I understand it'll be contested. I don't think with what's been stated on the record this time and in the past, I don't think mediation in this case would be fruitful. Normally, I would order it, but it's
Thank you,
fine.
Judge.
It can come to the bench right away. File your motion for temp orders, and we'll give you a setting in an afternoon where I can dedicate some time to it.
thank you, Judge, I will.
Okay?
Just some clarification, Your Honor. This hearing will be in the future for the order setting hearing, Judge. The bench trial will be in person, or it will be via Zoom?
Well, he's gonna file a motion for temporary orders, and he's gonna file a motion for DCC. So
Okay.
whenever they do the DCC, they'll indicate whether it'll be bench or jury, and whether, if it is bench, if it'll be in person or via Zoom.
Okay, Judge. Thank you.
Okay?
Thank you, Judge.
All right. Anything else?
That's all I have, Your Honor.
Okay, I'm gonna set a tickler for February the 11th for those motion for temporary orders to be filed.
Thank you, Judge.
All right. Okay. Thank you. Y'all have a good day.
Yeah, thank you. Stay safe.
Okay, Mr. Moore and Mr. De La Garza.
Yes, Your Honor.
Okay, is this number 4 on the court docket?
Yes, Your Honor, it is.
Okay, CO 173573-I, Fernando Cortez et al. Versus Germania Farm Mutual Insurance Association et al. Announcements?
We are Michael Moore on behalf of the plaintiff.
Raul de la Garza, Your Honor, on behalf of the defendant. Your Honor, if I may begin, this is our motion for partial summary judgment.
You may.
Your Honor, just a quick background on this one. This is a storm homeowners insurance claim type lawsuit. By way of background, the homeowner was alleging that he sustained hail and wind damage to his home in Mission, Texas in March of 2015. About 11 months later, they reported the claim to Germania, who we're representing, and Germania sent out an adjuster to go inspect the damages. That adjuster went and inspected the damages to the home and found some damages, but ultimately decided that the amount of damages that he found was under the deductible. Then Germania sent out a second adjuster, a different person, who also inspected this home and also decided that although there were damages, that they were both, that the damages, the covered damages were under the deductible. So after Germania sent out its letters and everything, Your Honor, plaintiffs invoked the appraisal process. We responded to the appraisal process. Both appraisers had the choice of either getting a court-appointed umpire or agreeing on an umpire. That was not necessary because both appraisers agreed on the amount of loss and they signed that appraisal award. The appraisal award included the replacement of the roof and some painting of some fascia boards on the outside of the house. And that was it. They signed the appraisal award on July 12th of 2017. And then 6 days later, Germania fully and timely paid the appraisal award in the amount of $2,340.86. Now, the way the appraisal award is prepared, Your Honor, is there is either depreciation that can be recovered or cannot be recovered. In this case, because the insured homeowner did not pay that extra premium, there's depreciation taken from items that are not brand new and he cannot recover them. So the actual cash value, which is after depreciation is taken, was $4,960. Then Germania subtracted the deductible and paid in the amount of $2,340.86. Under the policy, Your Honor, this is absolutely all the actual damages that the homeowners are entitled to. So at that point in time, Your Honor, we paid the appraisal award, and this case was in County Court 4. We filed a motion for summary judgment at that point in time, and at that point in time, it was a full motion for summary judgment. The case law at that point wasn't clear. There were still appellate courts going back and forth as to what should happen after an appraisal award is rendered, what causes of action should survive, and what causes of action shouldn't. Then that case was transferred to this court, Your Honor, and since that time, there has been 2 recent Texas Supreme Court cases that went directly to the heart of the issue as to what should happen when an appraisal award is rendered and if it is fully and timely paid by the company like it was in this case. So before I begin my arguments, Your Honor, the main thing that I want to point out is that this is a motion for partial summary judgment, not a full summary judgment. And our arguments here are based on those 2 cases that I'm going to discuss here further that have been reaffirmed dozens and dozens of times since they came out in 2019 and that are directly in line with the facts of our case. Now, with regard to plaintiffs' live pleadings, Your Honor, we can divide the causes of action into 3 main groups. The first one is a breach of contract. The second one is extra contractual things such as Chapter 541 of the Texas Insurance Code, bad faith, fraud, common law of duty of good faith and fair dealing. All that falls into the second section. And the third section is Chapter 542, Prompt Payment of Penalties Act. That essentially says, did you pay what you were supposed to pay on time? This summary judgment that we're arguing here for today, Your Honor, is addressing the first 2 out of those 3. We're saying that the breach of contract should be dismissed as a matter of law, and that the violations of the insurance code, bad faith, fraud, everything except 542 should also be dismissed as a matter of law. Now, the case that I rely on, Your Honor, is a Texas Supreme Court case. It is cited multiple times in my motion, and it is the Ortiz case, Ortiz versus State Farm Lloyds. This is, again, a Supreme Court of Texas case that deals with a post-appraisal matter, which is very, very similar to ours. Just a very quick background. In the Ortiz case, the homeowner filed a claim with State Farm. State Farm also sent out 2 different adjusters, inspected the home in that case, and both adjusters also agreed that the amount was under the deductible. Ultimately, State Farm in that case invoked appraisal. They filed a full summary judgment. The trial court granted, Court of Appeals granted, and then the Supreme Court granted everything with the exception of the Chapter 542, which they remanded. Again, we're not asking for 542 in this one. We're just asking for everything else that the Supreme Court of Texas granted in that Ortiz case, aside from 542. Now, as you know, Your Honor, as you can see, our case is nearly identical to Ortiz. Both of us had two independent appraisers or adjusters, I'm sorry, go out there and say that the damages are under the deductible. Both of them had an appraisal award, and in both instances, the insurance company fully and timely paid the appraisal award. Now, there is an argument that was addressed in the Ortiz case that plaintiff's counsel is trying to argue in ours, and that was specifically rejected, and I believe it's important enough to highlight here. And that is when the appraisal award is higher than the adjuster's estimate, that doesn't automatically mean that there was a breach of contract or a breach of extra contractual things. Now, the Supreme Court specifically stated that if it followed plaintiff's flawed logic, that because the appraisal award was higher, then the insureds would be, quote, incentivized to sue every time an appraisal yields a higher amount than the insurer's estimate, regardless of whether the insurer pays the award, thereby encouraging litigation rather than short-circuiting it as intended. Appraisal is intended to short-circuit litigation. What they're saying is, if every time the appraisal award is higher, it invites litigation, then the appraisal award would be moot, or the appraisal process, and it shouldn't exist. So the Supreme Court specifically said just because the appraisal award is higher than the initial one should not mean, or does not automatically mean, that there was some kind of breach of contractual or extra contractual causes of action. It does, however, mean that if the insurance company fully pays this appraisal award, no matter how higher it is in this one, then it should do away with the first and second groups of causes of action, Your Honor. The Ortiz case also addresses extra contractual arguments, which is in our second group, and the court held that because the insurer, in that case, State Farm, paid the policy benefits through the appraisal process, the plaintiff cannot maintain any bad faith claim, any statutory claims under Chapter 541 or anything except 542, which again was remanded. It wasn't ruled on as a matter of law, it was just remanded at trial court. Therefore, Your Honor, in accordance with this binding Texas Supreme Court case, we believe Jermaine is entitled to a breach of contract and extra contractual damages, judgment as a matter of law on all those, with the exception again of 542, Your Honor. There's another case, Your Honor, that we did cite in our motion. They went hand in hand with Ortiz, but that one is a Barber Technologies case. That one is very similar, but because that one deals a lot with 542 and we're not asking the court to grant summary judgment on 542, we're not going to go ahead and harp too much on that, but I did want to include that because that's another seminal case of post-appraisal matters. Now, plaintiffs did file a response a week ago, Your Honor, to our motion for summary judgment. There were many things therein that were, we believe, misleading and false, and we want to go ahead and set the record straight on them. In paragraph 1, Your Honor, to their response, plaintiffs cited the appraisal clause that essentially dictates how the appraisal process should be handled. And it essentially says that the insured will retain the right to bring suit against Germania following the appraisal award. We're not arguing that they do not have that they're not entitled to file suit, which they did in this case, but it has to be subject to Texas law, which they cited and which is included in the appraisal provision. Here, Your Honor, Texas law is clear, and because there was a full and timely payment of the appraisal award, it entitles Germania to a full summary judgment on everything except 542 penalties. In paragraph 2, Your Honor, plaintiff stated that the appraisal award that was paid of $2,340.86 was conditioned upon an execution of a release of all claims. That is not true, Your Honor. We paid the $2,340.86 appraisal award, but it was not conditioned upon the execution of a release of all claims. We did send a release with this check, but never did we say you must sign the release or you don't get access to these funds. We didn't hold a check in our office and said, once we get the release, then you'll have access to these funds. At that point in time, before the Supreme Court issued its rulings, we believed, based on Court of Appeal rulings, that once we fully and timely paid the appraisal award, that they would be entitled, that we should get a release of all claims and be entitled to, that should be over. But we never ever conditioned the payment upon that. So that is a false statement, Your Honor. In paragraph 3, plaintiffs referred to our motion for summary judgment that was denied back in 2018. That was in County Court 4, Your Honor, and that is correct. It was denied. However, two major distinctions. That one was a full summary judgment. This one isn't. And that 2018 one was before the two seminal cases that I've already discussed in this case that came directly from the Texas Supreme Court to provide guidance as to what should happen in these types of cases. Prior to 2019, when we filed this motion in the other court, we just had Court of Appeals instructing nothing binding. Now we have binding, unambiguous case law, Your Honor, that dictates what should happen to these cases. Let's see, in paragraph 4, Your Honor, plaintiff cited other recent Supreme Court cases in Hinojos and Biazari, and essentially suggested that because those two came out, that Ortiz and Barber Tech, the cases that we're relying on, are inapplicable. This is also wrong, Your Honor. The Ortiz and Barber Tech cases are still good law. We key cited them this morning. I've been key citing them for the past years. They're still good law, and this can easily be verified by either key citing or shepherdizing, whatever system y'all use. And second, the Hinojos and Biazari cases are not applicable to the facts of our case. The Hinojos case only applies to Chapter 542 penalties, which we're not seeking in this case. And the Biazari case also only deals with Chapter 542 penalties. But in addition to that, it only specifically deals with policies where there is a unilateral appraisal provision, which means only the insurance company can invoke appraisal. That is not the case in our case. In our matter, Germania can invoke appraisal or the homeowners can invoke appraisal. So it's not unilateral. And in this case, the homeowners are the ones that started the appraisal process. So that Biazari case is also not applicable, Your Honor. Both the cases that plaintiff cited to, Hinojos and Biazari, again, specifically deal with Chapter 542, for which we are not seeking summary judgment. Paragraph 6, again, the plaintiffs make a false and misleading statement that they were forced to sign a release for reasons stated before, Your Honor. That is not true. In paragraph 7, they argue that the MSJ is premature. It is not. It is more than ripe. Plaintiffs invoked appraisal. The appraisal process was completed. The appraisal award was signed. The full appraisal payment was issued. There's nothing more that the Texas Supreme Court has said that is necessary in order for us to obtain judgment on these matters. Paragraph 19 and 22, Your Honor, bring up adequate interest and attorney's fees. We paid what we believed was the prompt payment of claims interest. Plaintiff's counsel views it differently. However, that can be addressed in court in front of a jury because that is dealing with 542. 542 allows them to recover the interest and recover attorney's fees. To the extent that they're arguing whether or not the interest was a correct payment or not, that is a 542 issue that should be taken up at trial. Right now, what we're trying to do is get summary judgment on everything else, like the Supreme Court said that we're entitled to if we pay the appraisal award like we did. And again, Your Honor, paragraph 27, they cite Barber Tech. Barber Tech is specifically dealing with Prompt Payment of Claims Act, for which we are not seeking 542. At no point in plaintiff's motion for response to their summary judgment, Your Honor, do they cite anything that would overturn Ortiz, that would overturn anything that the Supreme Court has stated regarding breach of contract and 541, fraud, common law duties, anything other than 542. Their arguments are geared for 542, but we are not seeking summary judgment on 542. Your Honor, it does not get any clearer than this. A lot of times we get Supreme Court cases where we try to match the facts, we try to draw parallels. This Ortiz case is as close as it can possibly get to our case in terms of damages found, number of times the property was inspected, full and timely payment of appraisal award. It does not get any clearer than that, Your Honor. So because the Texas Supreme Court case did grant State Farm summary judgment on everything except 542, we're respectfully asking this court to rule in accordance with that Texas Supreme Court case law and grant summary judgment on breach of contract, extra contractual damages, everything except for 542 penalties. And one more thing, Your Honor, I know plaintiff's counsel said in his response that there was no breach of contract in their current pleadings, although there isn't an explicit cause of action under their cause of action section says breach of contract. There are certain paragraphs, specifically 23, 31, and 52, where they allude to, or in some cases specifically state that there was contractual duties that we violated. So because there are mentions of contractual violations, we are thus seeking breach of contract summary judgment as well, Your Honor. Thank you.
Okay, Mr. Moore.
Yes, Your Honor, I'll be brief. So, Your Honor, this is my clients own a house over in Mission. Their home sustained property damage. They have a policy of insurance issued by Germania. And the Germania policy, Your Honor, there is a mandatory condition precedent in that policy that requires the parties to go through the appraisal process before you can file suit. It's a mandatory provision, Your Honor. And so the plaintiffs complied with that mandatory provision and went through the appraisal process. And so this lawsuit stems from the improper adjustment and as well as the conduct after the appraisal process, Your Honor. This is very important because after the appraisal award was issued, Mr. De La Garza's law firm sent me a letter dated July 18, 2017, Your Honor. In that letter, they are providing the check as well as a release. And the law is very clear, Your Honor, is that an appraisal award must be tendered and paid unconditionally, 100%. This is attachment exhibit 1-2 to the response to the summary judgment, Your Honor. And Mr. De La Garza does kind of mention that, but he says it's not, it wasn't required. But this is a letter from his law firm saying that, here's the money, and by the way, here's a compromise and settlement agreement. You need it, and this needs to get signed. And that's a violation of the Texas Insurance Code. It's post appraisal. And another thing, Your Honor, is that Mr. De La Garza talks about these two seminal cases, the Barbertech and Ortiz. But since Barbertech and Ortiz have been issued, the Texas Supreme Court has talked about other factual situations. In a case called Bassetti versus Guide 1 National Insurance, this is also a Texas Supreme Court case involving an appraisal clause. And on the Bassetti case, Your Honor, that was the court called a unilateral appraisal clause, which required only allowed one party to invoke appraisal. But it's very similar to ours, is that before the plaintiffs can file suit, and of course, there's a lot of hurdles we have to jump over to file lawsuits against insurance companies. And one is, a 542A demand. They have to send a demand because they claim they want to have an opportunity to settle the case. But before you get to a 542A demand, Your Honor, we have to invoke appraisal as a mandatory condition preceding. And very similar in Bassetti, and the Supreme Court came back in Bassetti, Your Honor, and said, and normally under Ortiz and Barbertech, the case would be dismissed other than the payment of attorney's fees and prompt payment penalties. But in Bassetti, Your Honor, they sent it back to the trial court dealing with a unilateral appraisal clause, which is like ours, a mandatory condition proceeding. And they went back. It was sent back to the trial court, Your Honor, for further proceedings on the issue of the conduct of the insurance company that relating to violations of 542, which is extra contractual claims. Which is exactly what we're talking about here, Your Honor, is that before the plaintiffs can even file a lawsuit against Germania, that we have to go through a mandatory appraisal process to determine the amount of the loss, which is just like Bassetti, Your Honor. And so in that court, the Supreme Court, which is after Ortiz and after Barbertech, because Barbertech and Ortiz didn't deal with mandatory condition precedents like the appraisal clause, Your Honor. So in our case, Your Honor, we have the survivability of extra contractual claims that's allowed under Bassetti, as well as the conduct of Mr. De La Garza's law firm, as well as the insurance company, in demanding a release to be executed as a condition precedent. These are all acts that are bad faith, Your Honor, that are not wiped away by simply paying the appraisal award, Your Honor. And I'll point out to the court, Your Honor, this is the second time we've been in front of the court. On the first time, it was a full summary judgment because Mr. De La Garza in his pleadings asserted that the plaintiffs lose because they pay the appraisal award and we get zero. Well, he was wrong in that motion and he lost that motion. And here we are again. That motion is practically verbatim as what we're looking at here. They've added a couple more paragraphs, but now he concedes that we were right and he was wrong in the first motion for summary judgment, and that the only thing we get are the attorney's fees that we get to litigate under the prompt payment provision, which is exactly what we've been arguing from the very beginning in this case, Your Honor, is that after the appraisal award. And we've always argued this. I've been down this road many times with Mr. De La Garza, and we've fought this exact same fight over and over again, that prompt payment and attorney's fees survive the appraisal award. I'll argue that before Barbertech, and I'm arguing it now, Your Honor, that survives that. But the conduct of Mr. De La Garza's client relating to the payment of the appraisal award as to the conduct and the adjustment survive the appraisal provision because of Bassetti. Bassetti specifically allows for that. And so for those reasons, Your Honor, it should be denied in all respects. Now, I went back through my pleadings before the hearing here this morning, and I went through it pretty quick, but I didn't see any causes of action that are couched in breach of contract, Your Honor. And so to the extent that Mr. De La Garza has pointed out, I've written them down. I'll go back and relook at it. That's really more of a special exception, Your Honor, because you really need to go through special exceptions before you go to summary judgment. And there've been no special exceptions on those provisions. And I disagree with his interpretation of those paragraphs, because those paragraphs specifically deal with Texas insurance code violations as opposed to breach of contract. And to the extent they're breach of contract, I mean, if it's correct, I'll amend those out. I don't think they do, Your Honor. But to the extent, the bottom line is this, Your Honor, is that the appraisal is a condition precedent, mandatory. We can't sue until we go through the appraisal process. Bassetti versus Guide 1, which is in my response, Your Honor, Texas Supreme Court, April 17th, 2020, dealing with mandatory appraisal clauses, say that bad faith has survivability through that. There also is our right for the attorney's fees and the proper calculation of the prompt payment, Your Honor. And so for those reasons, Your Honor, for the second time, Mr. De La Garza's motion needs to be denied.
Okay, anything else to add, Mr. De La Garza?
Yes, Your Honor, I need to clarify some things here because,
Go ahead.
okay, so I think that it would be, I can point to you, Your Honor, and with the wonders of Zoom and screen sharing, if you'd allow me to, Your Honor, I can go ahead and share my screen so I can point out exactly what it is that we're talking about that might make it.
Okay, let me go ahead and turn that feature on. Go ahead.
Okay, Your Honor. Can you see my screen right there?
I can.
Okay, so this is Exhibit B10 to our motion for summary judgment, Your Honor. This is the letter that we sent after the appraisal award was signed, and here is the check. The letter states, Mr. Moore, as full and final settlement, please find the compromise settlement agreement. Please have your client sign the release. Also enclosed, please find check payable to Fernando Cortez, $2,340, which represents the appraisal award of blank, less the deductible of $2,620 for the payable amount of $2,340.86. Thank you for your assistance in this matter. Should you have any questions, please do not hesitate to contact us. And we send the check, Your Honor. If Mr. Moore is correct that it was conditioned upon that, Your Honor, the letter would have stated, please do not endorse this check. Please do not cash this check unless we get the signed release. Or simpler than that, Your Honor, we would not have enclosed the check. We would have kept the check and told them, hey, where's the release? Where's the release? Where's the release? We didn't do that, Your Honor. We sent the release because we thought we interpreted the law to be that before the Supreme Court cases, but we gave them the check not conditioned, Your Honor. They could endorse it right now. They could have endorsed it 2 years ago. I don't have the information as to whether or not it has been endorsed, but I'll say it on the record. Go ahead and endorse that check because we never, ever intended it, nor does it say anywhere in the letter that the cashing or the endorsing of the check is conditioned upon the signing of the release. That is not true, Your Honor. That is not accurate. We sent the release with that letter, but we never, ever conditioned it upon that, Your Honor. So I want to make that clear, and I wanted to go ahead and share that exhibit with the court. Mr. Moore also says that he cites Biassatti. He does, Your Honor. And I'll go ahead and share my screen to that Biassatti court opinion, Texas Supreme Court. I addressed this in my initial argument. He addressed it in his response, Your Honor. This is the Biassatti case that he's relying on. It's a Supreme Court of Texas case, April 17, 2020, holding. The Supreme Court held that payment of an appraisal award did not foreclose award of damages under the Prompt Payment of Claims Act. That is Chapter 542, Your Honor. If we scroll down here, it's a per curiam opinion. At issue in this dispute is whether an insurance payment of an appraisal award obtained under unilateral appraisal clause bars an insured's claims under the Texas Prompt Payment of Claims Act, codified as Chapter 542 of the Texas Insurance Code, Your Honor. This is a Chapter 542 issue, the Biassatti case, which we are not seeking summary judgment on. We're seeking summary judgment on everything else except 542. But if Biassadi was intended to say, you know what, everything survives, like Mr. Moore is trying to say, then there would be a red flag on the Ortiz case, there would be a red flag on the Barber-Tech case, and there would not be dozens and dozens of cases that have already cited it until then. This case and the Hinojos case only specifically deal with 542. We are not arguing we're entitled to that summary judgment, Your Honor. So again, there's some confusion of the issues right here and some conflation that's trying to be happening right now. These are separate and apart from each other. And this is specifically dealing with 542. If he wants to bring this up at trial for 542 purposes, we can bring our case law, but this is not what we're seeking for in this summary judgment, Your Honor. So again, the Biassadi and the Hinojos case are not applicable to the causes of action that we're trying to seek summary judgment on here today. Again, there's conflation of extra contractual damages. There's 541, which deals with the handling of the claim, and there's 542, which deals with the payment and prompt payment of the claim. We're seeking summary judgment on 541 and everything else, not 542. So when Texas Insurance Code is broadly stated or argued, we want to make sure that the court sees that distinction, because that's the distinction that the Texas Supreme Court made when it decided to grant summary judgment on some extra contractual, but not 542. Mr. Moore also said that we lost in 2018, Your Honor. We have already stipulated or stated here on the record why this one is different. It's partial, and more importantly, there is now binding, unambiguous Texas Supreme Court case law that was not afforded to us, so that we do not have access to prior to 2018 when the first MSJ was ruled on. Now that we do have the court's guidance, the Texas Supreme Court's guidance, we re-urge this motion, and the applicable case law that we now cited in the second motion is Supreme Court binding, not necessarily just persuasive. And Mr. Moore said that his amended pleadings or his live pleadings do not state contractual provisions. I'll go ahead and share my screen again. I did state when I mentioned my initial argument, Your Honor, that it's not specifically stated in the causes of action. But for example, 31 here, defendant insurance company failed to perform its contractual duties to adequately compensate plaintiffs under the terms of the policy. That is specifically stating that we breached the contract. It is not stated in a cause of action such as the other ones are under this paragraph, but there's still reference to that. There's still reference to contractual duties. So what I don't want happening is him saying that there wasn't any contractual things in there, and then we get to trial, and then he's like, oh, well, by the way, here it is. It was in paragraph 31. You should have read the pleadings. So because there are contractual allegations in his live pleadings, and because the Texas Supreme Court cases state that we're entitled to summary judgment on breach of contract after we've paid the appraisal award, that is why we're specifically seeking it on breach of contract and on everything except 542, Your Honor.
Your Honor.
Moore, did you want to add anything else?
Yeah, I'm going to have to, Your Honor. Two quick things, Your Honor. Well, you know, Mr. De La Garza just showed you the letter from his law firm enclosing a copy of the release and compromise settlement agreement. And now he's got all these excuses that it doesn't mean what it says or whatever. I mean, that's going to be a jury question, Your Honor. And he can come up with whatever excuses he wants to come up with, what that's supposed to mean. But clearly, you know, they sent the check with the release. You know, if it quacks like a duck, if it flies like a duck, what is it, Your Honor? The second thing is that he showed you Bassetti, but he didn't scroll all the way down. And I'll just go ahead and read it for the record, Your Honor. In the Bassetti case, again, that's the unilateral appraisal clause, and in that case, they were contending that all this bad faith on before the appraisal is potential. You can litigate it, and the Supreme Court. Of course, this case is a couple of years after Ortiz, and Ortiz didn't deal with the unilateral appraisal clause, and the Texas Supreme Court said, and I quote, it says the Court of Appeals also held that Top Dog, which is Bassetti, that Top Dog's claim for breach of contract and bad faith were barred. And that's what Mr. De La Garza is arguing here. It says this holding comports with Ortiz generally, but Ortiz did not involve a unilateral appraisal clause, and they cite Ortiz. Thus, Supreme Court, we did not consider whether payment of an appraisal award under a unilateral appraisal clause would have the same effect as to these claims. The trial court may consider that question on remand. That's right out of Bassetti, Your Honor. And they're talking, and that's all dealing with all these extra contractual bad acts. And it survives Bassetti because the court, the Texas Supreme Court, if there was such a bright line rule, Your Honor, that Mr. De La Garza was trying to waive before this court, then that paragraph should not be in there. They should be a zero on the extra contractuals. They said because it involved a unilateral appraisal clause, we're going to send it back down to the trial court and let you guys consider that. That means it's not that it survives as a matter of law, Your Honor. And so for those reasons, Your Honor, the extra contractual claims survive, the prompt payment claims survive for attorney's fees. And if he's got a problem with my pleadings, he can file special exceptions, but he just told you, Your Honor, that we don't have a cause of action pled for a breach of contract. He specifically just said that. So you can't award a summary judgment on a cause of action that's not pled. I might talk about it in the facts, but if it's not that cause of action pled, you can't grant a summary judgment on that, Your Honor. So for all those reasons, Your Honor, it should just be flat denied.
Your Honor, if I may, this will be brief, Your Honor, but Mr. Moore is saying something that the Ortiz case has. Again, I'll go ahead and share my screen. Let's go to the Ortiz. This is the Ortiz case that I'm citing, Your Honor. Here's the appraisal clause on that Ortiz case. If you look at our motion, Your Honor, it is nearly identical. If you and we fail to agree on the amount of loss, either one can demand appraisal, either makes a written demand for appraisal, each should then select an appraiser, et cetera, et cetera. Each appraiser shall be paid, other expenses of appraisal shall be paid equally, et cetera, et cetera. Your Honor, making it a condition precedent to suit does not equate, even though Mr. Moore is trying to say it does, that it is unilateral. What unilateral means is only one side can invoke it. In our case, Your Honor, the plaintiff invoked it. Germania could have invoked it, but the plaintiff invoked it. Nowhere in that policy, Your Honor, does it state, and I can go ahead and share the screen to our policy here. This is Exhibit A, Your Honor, to our motion. And here is the appraisal clause. Subsection 10, if you and we fail to agree on the amount of loss, either can make a written demand for appraisal. That word either says that either side can make a demand for appraisal, which means that it is not unilateral. So just because Germania and every other insurance company saying it is a condition precedent to filing suit does not make it unilateral, because Germania could have invoked it or plaintiffs could have invoked it. And in this case, plaintiffs invoked it, Your Honor. We just wanted to go ahead and clarify that, because the only thing that he's hanging on to on the Biazzati case is saying that it's unilateral. That is not the case in our case, Your Honor. And again, if Biazzati intended and the Supreme Court intended to say that everything survives after an appraisal award is fully and timely paid, then there would be a big red flag on Ortiz, there'd be a big red flag on Barbertech, and that simply isn't the case, Your Honor.
Okay. Final arguments, that's it. Did you all want to put anything else on the record?
Your Honor, just I don't have all the attachments here. I'm not working from home, but that policy does have a mandatory condition precedent. I just want the court to realize that. He didn't read that in the record, but it's a mandatory condition. In other words, we couldn't sue Germania until we go through the appraisal process. That is a mandatory condition precedent, Your Honor, and so that's why the study is relevant. Thank you.
Well, I do see that your orders are on file, and so I'm going to go ahead and take this under advisement. And I should be issuing a ruling by February the 18th.
Thank you, Judge.
Thank you, Your Honor.
Okay.
That's all I have. Excuse.
Yes, you may. Thank you. Y'all have a good day.
You too. Bye.
Likewise.
Okay. All right, I believe the rest that were pending were just the ones from Mr. McLaughlin, and we'll go ahead and give him a new date when he submits those order setting hearings, okay?